it is temporary doesn't mean that the article is temporary for all time to come. You can't interpret the marginal note in that fashion.
It's 368 power, right?
In this case, no, 356 power. Because of 356, Parliament is exercising that power. So the Parliament is the legislature. And because it's a constituent assembly, Parliament of India is the constituent assembly, and therefore we can do what we do. When your lordships talk about temporary mullets, really you have to look at the constitution. Because it had to be temporary in 1950. There was no element of permanency. It could not have been. And this is the marginal note. Give it to my lord. You have copies?
This is a marginal note. There's no question about it. It is a marginal note.
Yes. So, Malaj, you can't be saying, which is what your lordships are concerned with, but it was temporary. But that's only when you look at the marginal note. It had to be temporary because there was no other way to deal with it. You couldn't have said it is permanent.
There's no doubt still about the fact that this forms a part of Part 21 of the Constitution, which still deals with temporary and special provisions.
I'm not disputing that. These are all different provisions, Malad.
They've all been clubbed together in Part 21.
That's correct. But we looked at it in the context of, Malad, what was going to happen in the northeastern regions. Gujarat and Maharashtra together, what was to happen there, issues of Marathwada. So those councils had to be created, boards had to be created. That's why they were temporary. Telangana, that's why they were temporary. Not for any other reason. And that's why this was also temporary. It's the same logic. But the fact that it is temporary doesn't mean that the article is temporary for all time to come. You can't interpret the marginal note in that fashion. So the language of 368 to our mind is, I'm sorry. If you look at the heading, Malaj, it says temporary and transitional provisions. So 2 is temporary and 2 is transitional and 3 is temporary.
It's 368 power, right?
In this case, no, 356 power. No, it's 356 because they converted. What happened? Well, let me just, in one sentence, they say, in one sentence, I'll tell you what they did. They converted the Legislative Assembly into the Constituent Assembly. Right? Right, dissolved. They converted it into a Constituent Assembly. Then they said that now Parliament, because of 356, Parliament is exercising that power. So the Parliament is the legislature. And because it's a Constituent Assembly, Parliament of India is the Constituent Assembly, and therefore we can do what we do. That's in one sentence what they did. And they recommended to themselves. So instead of clapping by 2 hands, they clapped by 1 hand. Because they exercise the power of the legislature themselves. And because the legislature's consent was necessary to give that consent to themselves and abrogated 370. Unique, constitutionally a unique, unheard of. I will not use that expression. A procedure that is unknown to law. Because the objective was entirely different. And I've been saying that from day one.
That's how they brought in the...
10 minutes.
The proviso to clause 3 of Article 370.
Yes, yeah, because they understood it that way, that it required the previous.
And then what they do is they say that the Parliament exercising the powers of the Constituent Assembly,
Yes.
by virtue of the fact that the Legislative Assembly has been dissolved.
Yeah.
assuming that the Legislative Assembly was not dissolved, that could have exercised the power of the Constituent Assembly.
That's right.
Now that it has been dissolved,
Yes.
under 356, Parliament has the power to make laws with all aspects of whether it's
Correct.
list 1, list 2, or list 3. And then they exercise the power under the proviso.
That's right. That's right. So, Malad, actually, they understood 370 sub-article 3 in the manner in which I am, Malad, stating before your Lordship. It is their understanding right till the end. They don't understand. Which is why I wanted to bring it at this stage, Malad, so that now your Lordship knows, Malad, the larger picture, so to say. So we are going into interpretation of 370 sub-article 3, which they themselves accept, that the proviso applies. Power can you convert a legislative assembly into a constituent assembly? Which is that power?
As a matter of fact, Praja Sabha was turned into a constituent assembly, 1951.
Well, there was a direct election, I believe, well, at that point in time. Rajya Sabha was not all directly elected. But I'll check that out, but I don't want to make a statement and I'm sure of it. No, there was not. I mean, I don't want to give an answer without being sure of it.
Unless you are sure about it.
That's right. I always hesitate to do that. My learned friends are far more, articulate on those issues than I am.
Seized by the Rajah in 2051. Just about was by the power of Praja Sabha was conferred to the Constituent Assembly.
The power of Constituent Assembly was conferred on the Praja Sabha.
According to me, and I'll give that date, why should I say anything? The Constituent Assembly was directly elected in Jammu and Kashmir, but I don't want to, I must be sure of it before I say that. I know it says that Constituent Assembly consisting of representatives of the people elected on the basis of adult franchise shall be constituted forthwith for the purpose of framing a constitution. So I was aware of it, but I was not sure where it was. I just wanted to mention. Unlike us, we were indirectly elected, our Constituent Assembly. Anyway, Malas, kindly have a look at Keshavnan Bharati. This is volume 15. Volume 15 of
Yes, that's a good idea.
Case Law Compilation, PDF 236. Actually, 235. I'll start with paragraph 537. Volume 15, my lords. Volume 15, paragraph 537. Which is why I've been saying throughout my submissions, this was a political act to achieve a certain political purpose, dehorse the provisions of the Constitution. Page 235, paragraph 537.
We've got it on the screen as well.
Yeah.
Sorry, Mr. Sibal, sorry. I just wanted to answer my Lord Justice Gavai's question. I just sought to be unmuted. My Lord, there was a proclamation by Yuvraj Karan Singh for constituting the Constituent Assembly on 20th April 51. It was elected by adult suffrage. This was convened on the 31st of October 1951, its first sitting, and my Lord, it concluded its work on the 17th November 56, when it decided to adopt the Constitution on the 26th of January 57.
That's correct. Well, it's para 537 of PDF 235.
Whose judgment is this?
This is Malad's Justice Sheraton Grover. Well, the argument was that
Which page are you
368 refers to procedure